Modern Real Estate Practice, page 43. Upon receiving a complaint, HUD initiates an investigation. Within 100 days of the filing of the complaint, HUD either determines that reasonable cause exists to bring a charge of illegal discrimination or dismisses the complaint. During this investigation period, HUD can attempt to resolve the dispute informally through conciliation. Conciliation is the resolution of a complaint by obtaining assurance that the person against whom the complaint was filed, the respondent, will remedy any violation that may have occurred. The respondent further agrees to take steps to eliminate or prevent discriminatory practices in the future. If necessary, these agreements can be enforced through civil action. The aggrieved person has the right to seek relief through administrative proceedings. An administrative proceedings is a hearing held before an administrative law judge, ALJ. An ALJ has the authority to award actual damages to an aggrieved party, and if it is believed the public interest will be served, to impose a monetary penalty. The penalty can range from up to $16,000 for a first offense to $70,000 for a third violation within 7 years. The ALJ also has the authority to issue an injunction to order the offender to either do something such as rent an apartment to the complaining party or refrain from doing something such as acting in a discriminatory manner. The parties may elect civil action in federal court at any time within 2 years of the discriminatory act. For cases heard in federal court, unlimited punitive damages can be awarded in addition to actual damages. The court can also issue injunctions. The Attorney General, upon finding reasonable cause to believe that any person or group is engaged in a pattern or practice of resistance to the full enjoyment of any of the rights granted by the federal fair housing laws, may file a civil action in any federal district court. Civil penalties may result in an amount not to exceed $50,000 for a first violation and an amount not to exceed $100,000 for second and subsequent violations. The U.S. Department of Justice is at www.justice.gov. Recent cases can be found at www.justice.gov/CRT/about/what new.php. Complaints brought under the Civil Rights Act of 1866 are taken directly to federal courts. The only time limit for action is the state's statute of limitation for torts. Injuries one individual inflicts on another. In practice, in July 2009, HUD charged a landlord and the real estate company with 2 separate acts of housing discrimination for refusing to rent to families with children. Not only was their initial ad discriminatory, this is an immaculate, spacious 3-bedroom house for rent. No cats, dogs, or children, please. But when 2 different families with children called, the agent refused to show the home to them, stating the owner would not rent to families with children. Colon versus Bill, Weatherby, and others. State and local enforcement agencies. Many states and municipalities have their own fair housing laws. If a state or local law is substantially equivalent to the federal law, all complaints filed with HUD are referred to the local enforcement agency. To be considered substantially equivalent, the local law and its related regulations must contain prohibitions comparable to those in the federal law. In addition, the state or locality must show that its local enforcement agency takes sufficient affirmative action in proceedings, in processing and investigating complaints, and in finding remedies for discriminatory practices.